So the pleadings are closed. Discovery has been made. What now? We're entering into the planning phase, and Rule 37 gives effect to that. To start off with, there would be a notice of a date, time, and place for a pre-trial conference. It's a good idea that the parties agree upon that in advance to avoid any unnecessary delays. After the pre-trial conference has been set, both or either party can send a Rule 37.4 notice in terms of which they could indicate what admissions they would like to have made, inquiries, or any other matters that they would like for discussion. This gives advance notice to the opponent and allows for proper preparation for the pre-trial. Remember, the pre-trial is not just a box-ticking exercise. It is supposed to be intense planning. Whoever goes to the pre-trial must be a person that can make admissions on behalf of the client or foster agreements or make decisions. That's very important. Once the pre-trial conference has been held, in terms of Rule 37.6, a minute will be filed recording exactly what happened at that pre-trial conference. And there is a list of issues that would have had to have been discussed. The minute must then be signed by both parties, confirming the correctness of that which went down at the pre-trial conference. This minute is very important, and the parties are bound by what continued at that meeting. I mention this specifically because if there are admissions or decisions that are made, parties will be held to them by the court. And if you want to withdraw an admission, you're going to have an uphill battle to justify the reason for that. Once the minute has been prepared and signed, then it will be filed with the registrar in terms of Rule 37.7. Please note that in terms of Rule 37.8, a party can request a judge to order a pre-trial conference, or a judge could order a pre-trial conference without being requested to do so and request a report back. I ask you to bear in mind at this stage that Rule 37(a) makes provision for case flow management in the divisions relating to cases that have been decided upon, the sort of cases that have been decided upon. Rule 37 does not strictly apply to those matters, but we will discuss Rule 37(a) at a later stage. What's important is that parties remember that Rule 37 is there to assist the litigants and the court and can be an extremely useful tool in defining the issues and curtailing the length of the trial, and obviously a cost-saving mechanism. So practitioners are asked to not merely tick a box, but to invest in the contents of Rule 37 so that they can have a successful trial. It's been such a pleasure to share this pause with you today. Remember, your voice matters. So don't forget to like, subscribe, and tap the bell for the next tea adjournment.